Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in the series of labor law, let us learn how the settlement of industrial disputes are done. What are the methods of prevention? How is the settlement done? Let us go. Nowadays, industrial relations are not a bipartite affair between the management and the labor. Government is also playing an active role in promoting the industrial relations. The concept of industrial relationships has become a tripartite, among whom employees, employers, and the government. As we already know, prevention is better than cure. It is possible to settle disputes if timely steps are taken by the management. Such disputes can be prevented and settled in an amicable manner if there is an equitable adjustment between the management and the labor, then no need of any other settlements. The government has taken various steps to see the industrial disputes are settled peacefully. How? Firstly, the government has constituted a tripartite conferences for various industries where employees, employers and government are represented on these conferences. The other way is the statutory provision for the settlement of disputes is provided by the Industrial Disputes Act 1947. So in this settlement, how it happens is the government has constituted these conferences in various industries where who will participate? The employees, employers and the government will represent these conferences. Later what happens? The statutory provision is involved in the settlement of disputes, which is provided by the Act, Industrial Dispute Act 1947. So we have some methods how the prevention and settlement of industrial disputes is done. So here for settlement of industrial disputes we have two authorities, conciliation authorities and adjudicating authorities. Under conciliating authorities we have works committee, conciliation officers and board of conciliation. Under adjudicating authorities we have court of inquiry, labor courts, industrial tribunal and national tribunal. So all these seven will participate in the prevention and settlement of industrial disputes. So let us move to the conciliating authorities. The first one is works committee. So this committee consists of representatives of workers and employers. How equal number of representatives of workmen and employer will be there. Where it will be existing is it exists only in establishments where in which 100 or more workers are employed in the previous year. So it is the duty of works committee to promote measures for securing and preserving amity and good relations between the employer and workmen. So it also deals with other matters like conditions of work, whether the workers are working in a good condition or not, all the amenities are provided or not, safety and accident prevention, educational and recreational activities, promotion of thrift and saving. Promotion of thrift is nothing but giving them advices in making financial security, giving them educational motivation of how to make financial security for their life. So what it does not do is it doesn't deal with other items like wages, allowances, bonus and profit sharing, rationalizations and other retrenchment, layoff, provident fund, gratuity schemes, quantum of leave, incentives, housing facilities. It doesn't feel. Our works committee only deals with how the labor is involved in the conditions of labor, working conditions, amenities, safety. All these are only involved with the works committee. Next conciliating authority is conciliation officers. See, these conciliation officers are appointed by the government under the IDA Act 1947. So what are his duties? He has to do every possible way to make the settlement of the disputes in a fair and amicable manner. He has the authority in the case of public utility services, and he must hold the conciliation proceedings in whatever the manner that is prescribed under the IDA Act and according to the rules of the government. When no settlement is reached, he has tried hard in giving the settlement. If no settlement is reached, then the conciliation officer sends the report to the government for setting. He has taken so and so steps, but still the settlement has not been reached. So he will submit the report within 14 days of commencement of the conciliation. So, and he shall send the report to the government along with the memorandum of settlement if the settlement is done. So, and both the parties should sign that this is the thing which has happened and we have signed the memorandum of settlement. So the first conciliation and labor officer was appointed in the year 1934 for in the Bombay Trade Dispute Conciliation when Bombay Trade Dispute Conciliation Act was passed. The next conciliating authority is Board of Conciliation. Here only conciliation officer is only up to the public utility services. The Board of Conciliation will also extend its services to the general services as well as to the public utility services. What does this Board of Conciliation do is they will investigate the dispute in all the matters. How is it affected, what is the purpose, how the parties are involved. So it will first investigate and later they will bring a fair and amicable settlement, and this report will be sent to the government by the board within the whether if it is settled within 2 months of the date, whether the dispute is settled or not, they have to send the report. We have done so and so steps, and these are the things which are done during the settlement, and they will again sign the parties will sign that settlement has been done. This report should be sent within 2 months after during the settlement, and if the settlement has not done, then also they have to send the report to the government within 2 months of the dispute was referred. Next comes this adjudicating authorities. The first is court of inquiry. The government may appoint a court of inquiry for inquiring how is the industrial dispute happened. The court may consist of one person or more than one person. If only one person is there, that person will be the chairman. And the court shall inquire what is the matter, and it will submit the report to the government within a period of 6 months. Next comes labor courts. The government will set up labor courts for dealing the matters specified only in the second schedule of the Industrial Dispute Act. What are the matters? The legality of the order passed by the employer under standing orders, application and interpretation of standing orders, discharge or dismissal of workmen during the reinstatement, grant, relief of the workmen wrongfully dismissed, withdrawal of customary concessional privilege, illegality or otherwise a strike or lockout, and all the matters other than those specified in the third schedule. So the labor courts will inquire, and it will deal and it will settle the disputes which are specified in the second schedule of the IDA Act 1947. Next comes the Industrial Tribunal. Let us look first into the National Tribunal. A national tribunal is constituted by the central government for the adjudication of industrial disputes involving questions of national importance. A national tribunal consists of one person only to be appointed by the central government, and a person who is a judge of high court or he have held the office of the chairman of the labor appellate court tribunal. He is eligible for the appointment of this tribunal. The next important adjudicating authority is the Industrial Tribunal. The Industrial Tribunal is appointed by the government for the adjudicating of industrial disputes relating to the matters specified in third schedule according to the IDA Act 1947. So the second schedule industrial disputes are related to the labor courts, and the Industrial Tribunal will adjudicate the disputes related specified to the third schedule of IDA Act. So what are the matters? Wages, allowances, compensatory and other allowances, hours of work, rest intervals, leave with wages and holidays, bonus, profit sharing, provident fund, gratuity, shift working allowances, and other standing orders, classification by grades, rule of discipline, rationalizations, retrenchment, closure of establishment, and any other matters that are prescribed in the third schedule. So this is the duty of the adjudicating officer who is appointed for the Industrial Tribunal. So Industrial Tribunal consists of only one person who is appointed by the government, and he should be either the judge of a high court or district judge for a period not less than 3 years, and he makes an award after hearing the parties to the dispute, and the award is binding to the parties. So these are the adjudicating and the conciliating board which are involved in prevention and settlement of the industrial disputes.